Welcome everyone, and welcome today to a new interview of the ICJ. We are very excited actually to bring to you the news of a case that the International Commission of Jurists has won, and a case that has much importance for children in Europe and for international law. The case is ICJ versus Czech Republic, and it was brought before the European Committee on Social Rights, and was brought by the ICJ together with the Forum for Human Rights of the Czech Republic, an NGO in the Czech Republic. And we have here with us the key lawyer that worked on the case. It's my colleague, Karolina Babicka, that will be able to tell us much more about the case and tell us why it's important. Thank you for joining us, Karolina, and welcome here. How are you?
Good. Hi. Thank you very much for having me.
So it is kind of exciting. It doesn't come every day to win a case like that. And I think the most important thing to start off is understanding what's this case about, in a sense. What situations are we talking about in this case?
Yeah, exactly. So it is a really an important decision, and it concerns children below the age of criminal responsibility that find themselves accused or suspect of having breached the law in the Czech Republic. And it concerns in particular access to procedural rights of these children. So they very often do not have access to any legal assistance, and also just end up in court really unnecessarily. So to give you an example of a case that we used actually in this collective complaint was a boy who was 14 years old, who was allegedly committing an assault against his teacher at his school. And immediately after the incident, he was detained and taken to the police station, where he was held for about 7 hours. And during that time, he was not allowed to contact anybody. He was interrogated without being informed about the right to remain silent, without actually being able to contact his parents or his lawyer. He was also subjected to fingerprinting and extracting of DNA, again, in the absence of any support. So, and cases like this happen, unfortunately, quite often. These are about a third of all the cases in the Czech juvenile system are children below the age of criminal responsibility, which is 15 in the Czech Republic. So there's often also cases of children with serious intellectual disability, for instance, that would still be interrogated for many hours by the police, being put under pressure without any access to procedural guarantees, and especially without any access to a lawyer. So yeah, even though these children are actually below the age of criminal responsibility, so they cannot be held criminally liable, they may still be subject to pretrial criminal proceedings, such as I described, the interrogation by the police, and they may be also subject to very concrete sanctions, even including deprivation of liberty in, for instance, educational correction centers, or children's homes with schools or psychiatric hospitals. So, and you know, there is a law, a Juvenile Justice Act in the Czech Republic that covers both age groups of youth, children below the age of criminal responsibility, and then juveniles aged 15 to 18, where the juveniles actually do have quite good, good access to procedural rights. They have access to have legal assistance from the start of the pretrial stage. They also have access to diversions, so alternatives to the proceedings, such as mediation or a settlement or conditional termination of criminal proceedings, which is also something that children below the age of criminal responsibility do not have access to. So they may find themselves subjected to very formal judicial proceedings, when being, for instance, accused of very petty offenses.
So basically, what we find is a situation I didn't even know. There's a situation where children which are below the age of criminal responsibility may be worse off even the children are subject to the ordinary juvenile justice system, so above 15 years old. So for every person who's a parent, etc., if a child makes a mistake in an age below criminal responsibility, they could actually have less human rights guarantees than adolescents which are almost adults. That's actually very interesting. So is this the reason why the ICJ brought the case? Why the International Commission of Justice thought that this was a case to bring, and why did the ICJ bring it to this body, to the European Committee on Social Rights of the Council of Europe?
Yeah, exactly. I mean, we could see that really there are very serious systemic flaws in the Czech juvenile justice system, depriving the specific group of really particularly vulnerable people, children below the age of criminal responsibility. They were really being deprived of their rights. And as we work towards access to justice for the most vulnerable, this seemed like a very important case. And we were alerted to the situation by Forum for Human Rights, an excellent Czech human rights organization whose lawyers have been pointing to this issue for many years. So this situation seemed very clearly violating a number of international human rights standards, including the Convention on the Rights of the Child, the International Covenant on Civil and Political Rights, the European Convention on Human Rights, but also the European Social Charter, and in particular, the Article 17, providing for social and economic protection of children. A number of other international legal standards are really being violated by this law and practice. So in 2017, the ICJ and Forum have lodged this collective complaint to the European Committee on Social Rights, which oversees the implementation of the European Social Charter with regards to access to procedural rights of children below the age of criminal responsibility. I mean, one reason why we decided also to bring the collective complaint as opposed to targeting perhaps other mechanisms is exactly that it is this systemic issue and the systemic practice and gap in the law that can be very well addressed by such a collective complaint. And in addition, usually a litigation at international level can be quite difficult or burdening for the victims, and especially when these were cases of very young children who would have to face the proceedings, and also very likely they would not be children anymore when another mechanism would have decided their case. They wouldn't have been really then able to even benefit from the decision personally. That's also when it can be quite practical to bring a collective complaint. While there was quite a lot of evidence, we were able to really show the systematic practice and impact on children and the statistics. So yeah, these were basically all the main reasons.
Absolutely, and that also helps and assists the fact of not bringing children in the middle of the proceedings, which of course may have an adverse impact on them. I think that's very considerate. So you have followed everything from the draft of the first complaint to the answers to the state's replies and justifications. These things people think is the last decision, but it's years of work, of evidence gathering, of reporting, of legal thinking and research. So again, congratulations for that. How, in all of this, and this is the lawyer a bit asking and talking, what was the argument of the state to actually maintain this, and what has the committee decided in the end? This is why this is a positive decision.
Yeah, I mean, there were a number of different arguments. I think one quite interesting argument that was brought by the state, by the Czech Republic, was really when they were actually at all questioning whether, you know, the admissibility of the complaint at all for a violation of a right under the European Social Charter, saying, you know, that fair trial rights could not be at all protected under this instrument. So in that specific case, I think this was really important that the committee emphasized once again that there is really no such thing, such as a clear-cut division between civil and political rights and social rights, and that there is this interdependence between fair trial rights and child's well-being. So also, you know, pointing to its past jurisprudence and jurisprudence of other bodies. So I think this was, for instance, also, this is also one added value really of the judgment of the decision of the committee. I mean, overall, the committee found that there was a violation of Article 17. So it found a violation for based on two grounds. First of all, on the first ground, the committee found that the state must ensure mandatory legal assistance to children below the age of criminal responsibility already in the pre-stage of the proceedings, you know, because children need the lawyer to understand and follow the proceedings, to understand.
We need it as adults, imagine as children.
Exactly. That's really basically just, you know, bringing the rights of children even younger than 15 to the level of the adults and children that are 15 to 18 years old. Basically, yeah, all the different aspects, such as, yeah, being aware of the fact that they have the right to remain silent or to prepare their defense. And then the second legal ground, where the committee emphasized the importance of diversion. So this kind of alternatives to the proceedings, such as settlement, mediation, or conditional termination or withdrawal of criminal proceedings. So, you know, that the children would not always have to end up in the court, even for really small offenses or for very small reasons. Because this is like something that is, again, available for the children that are 15 to 18 years old, but this is not available for the younger ones. So this is really important. And in this case, the committee also really emphasized the need for including as much as possible the restorative justice principles for all children. So this was really important, and it also clearly emphasized, you know, the rights-based approach and as embedded in the Convention on the Rights of the Child.
And this is fantastic. But and I want to ask you, also for a layperson, as you know, we are talking about children. One that the definition that I always find a bit odd, but I can't find a better one, where it says children in conflict with the law. But children who are faced with situations that touch upon what we call criminal law offenses, etc. But still they are children. And we are in a different system. It's a reality we rarely think we may face as human beings, but it may happen to everyone. And what I meant is, by giving this introduction is, you know, as human rights lawyers, we work very hard on many things. We rarely get a win. We can say it, and in this case, this is one of those situations where years and years of work bring to something that may change something. So I wanted to ask you really, in part as ICJ Legal Adviser, but also as Karolina Babicka, as why you think this decision is important? What do you think this decision can change for those children? And for children that may have to face the criminal justice system in their life.
Yeah, I mean, definitely, it is a really important decision and a great victory for us, but also really for Forum for Human Rights that have been, you know, fighting against the system for many years. I mean, indeed, it can hopefully finally help to fix this very unjust system currently in place in the Czech Republic, where children really, for, you know, very unimportant reasons end up in court. And, this can really impact so harshly on their lives, because, children being then placed to closed institutions, this has such a serious impact on their lives. And, I've actually seen, many years ago, back in the Czech Republic, situation in the prisons, where we did, some work and courses for the prisoners, while 95% of the prisoners we have met, they came from institutional care. So there is a general huge problem of, a high number of children being sent for various reasons to institutional care, who then, just are really not equipped for their life. And it really basically impacts them in a way that, when they're 18, they leave the institution, and within 6 months, they're back in another institution, which is the prison. And that is really like a pattern that we see. So, and that obviously has to do with a much broader societal issue and the very paternalistic approach of the society towards children. So I think, this decision can also be one small drop potentially in, changing the system and making really the rights-based approach, a norm, moving away from the welfare approach, where we still, treat children from this somehow like top-down, in this top-down approach, but really bringing it in line with the modern, last instruments of the Committee on the Rights of the Child. That's really, moving for many years now away from these paternalistic approaches. And I mean, we can think about the importance of this decision also for other European countries. I know that actually the Committee on the Rights of the Child, in its last general comment, also emphasized that it is not only important, what is the minimum age of criminal responsibility, but it's really important to also pay attention to how each state deals with children above and below the age. So I guess this is like a general concern, probably also in other countries. And I know in some EU countries, there has, for instance, been a discussion where, the age of criminal responsibility is lower than in the Czech Republic. And, sometimes states have been also criticized for that. So there have been discussions of actually raising the age of criminal responsibility. But then the question that some of the NGOs are very rightly asking themselves is, what will happen then to the children, below the age of criminal responsibility? How? Because they usually states have quite well developed, procedural rights for those that are actually criminally liable. So I think this decision can actually also serve as, as some kind of a guidance or inspiration also for potential reforms. And yeah, but first of all, I really hope this will help to change the current law and practice in the Czech Republic.
I couldn't agree more with you. And it's also very telling, also your experience, that basically a lot of criminal justice issues we find in adult age are created by the wrong policies we do towards children as well. And also this is really a societal importance, and we do, and this a reaffirmation is not a discovery, that actually implementing human rights law is not only a human rights law prerogative, but is also a security issue. It's meaning that by implementing human rights law, by giving rights bearer, by treating children as rights bearer, actually you create a better society and you create a safer society as well. So frankly, that's an amazing contribution. I want to thank you very much. I think this was really, really informative, and congratulations again to you and to the ICJ, to Forum for Human Rights for this. Now it comes the difficult part of trying to implement this, which is always when we have to make extra effort again. To that said, thank you for being with us, and I hope to have you for other conversations, and have a nice day.
Thanks a lot. You too. Have a nice day. Bye-bye.